Okay, looks like we've got everybody connected. So we'll go on the record now in People versus Frederick Hess. This is case number 226346. And if I could have both counsel put your appearances on the record, please.
Good afternoon, Your Honor. For the record, Mike Roll on behalf of the people.
Good afternoon, Your Honor. Bernard Jockins. I am appearing via Zoom on behalf of Frederick Hess, and I appreciate the court granting the courtesy of allowing myself, Mr. Hess, and Mr. Daniel to appear via Zoom today.
Certainly, and the record should reflect Mr. Hess is connected by Zoom as well. We are set for a hearing on several motions, Mr. Jockins, and what I have is a motion for disclosure of some information that you requested, and that's in the motion that you filed on November 27th with 6 categories of information. And then a second motion that you filed regarding the search warrants and some requested relief with regard to that. I did receive, Mr. Rolla, a response brief from people. I've had a chance to review all the filings of the parties. So Mr. Jockins, whichever way you'd like to proceed with oral argument, I'll just kind of let you address your motions as you want to address them here today, and then I'll have the prosecutor respond.
Thank you, Your Honor. First, I'm not sure if we'll be going forward on the actual Frank's motion today. I know that that would require testimony from the officer. I'm not sure if the officer is here or not. But what is really of particular importance today is the Brady motion and that for supplemental discovery. And I'll explain where we're at and what I'm looking for. And I'm going to cut to the chase right now. I will be asking for an adjournment or a dismissal, and I'm going to explain why, Your Honor. The court is aware of the history of this case. It's been going on for a while. I am not trying to jam up the process by any means. In my initial discovery demand, and I was not the initial attorney, that was Mr. Troish, and he did bring me up to speed. One of the big things is I asked for Cellbrite or cell phone data extraction. And what's not going to be in front of the court more than likely is today from Mr. Rolla and his office, I had received what would be the Cellbrite report, the PDF, Your Honor. I don't have any of the extraction materials. Now, in that information that I had received, one of the phones that they showed the report for was from Mr. Hess. And this is 728 pages that we had just received today. And we have a trial that's scheduled next month, Your Honor. And in the response brief, and I'm presuming that the court has this, and this would be on page 1 towards the end of the email from Detective Sergeant Jeremiah Roberts, which indicates the following, and I'll explain where I'm going, Your Honor. Mr. Hess was kind enough to give us consent to search his cell phone and perform an extraction. Detective LaCrosse is in the early stages of combing through that and has already observed some drug talk, and specifically Mr. Hess distributing Adderall pills to someone. We will continue looking into the phone and let you know what we see. I know you will need any of that for discovery unless it's too late. Please let me know if you need any further. Detective Sergeant Jeremiah Roberts. Now, that email was December 8th, 2023, right around 3 o'clock in the afternoon, which would have been last Friday. And I've received that follow-up. I believe I'd gotten this from Mr. Rolla. I don't approve the service. I believe that would be December 11th on Monday. And again, we have a trial that's scheduled for next month. Literally, we're a month out. Of another concern is, I need to look at all this information. And right now, with the way that all this information has come, and I know that I'm entitled to it, we had attempted to make arrangements with the SANE, the Straight Area Narcotics Enforcement Unit, which, they would be at the MSP. And I believe that the person in charge of it, Detective Sergeant Lacoste, is out for another 2 weeks. So I believe it's appropriate for an adjournment because we're going to need an expert to sort through any of that cell phone extraction. Because I understand the report, and I know that Mr. Rolla will agree that the report is what they want us, defense counsel, to see. That's not the complete discovery. That's not the extraction. And most courts that I practice in, generally I will get either a CD or a link in which I can actually go through the materials that are on that cell phone. And I don't have that. And that's going to take an extended period of time. In addition to that, again, it's 700, I believe it was 728 pages of 5 phones. And I believe that there were a total of 10 phones that were seized and consent was given. So I'm going to need to be able to review that material. And if maybe Mr. Rolla would be, so kind as to give me an actual CD, DVD, or link, I could get one of 2 experts that I had made communications with today, that they would be able to come out in the next couple of weeks. The people that I would be using would either be Adam Kelly, who is out of Lansing and he goes all over the state, or Josh Blanchard, who is also an attorney with his main office in Grand Rapids, who also practices throughout the state. And he is an expert in regards to the cell phones. In addition to that, Your Honor, I don't know if this was in the response or not, but we had also were slapped with a 404B notice that I'm not going to go into the merits of that at this point. I don't believe that that's necessarily appropriate or ripe at this situation. But I will say this is we'll need a little bit of time to respond to that. And one of the things that I'm struggling with here, Your Honor, is there's a confidential informant that's in this case, which is very common, or actually in this case, I believe there's 2 that were referenced and one that is really relevant, so to speak. And in regards to all the information with the confidential informant, it was indicated there's inculpatory information regarding my client, Mr. Hess. Regardless if there's inculpatory information, we're entitled to see everything that they have. And I'm sure that the court will agree. I know the court has extensive experience with police, prior to being on the bench. And police are here to serve and protect, not necessarily, sit around on things. I'm not saying that that's what happened here. I know we have the chief law enforcement officer for the county here that maybe can explain some of these things, but I'm asking for either any references to any cell phone information be suppressed. We allowed additional time to at least get an expert to review this. I have this information that is suppressed because we're a month out, and this email indicates on December 8th that they're going through the extraction materials now. And I understand that things come up with cases, and it's very common that, examples with cell phones, that this can lead to potentially other crimes, other things that happen, but at the same time, also exculpatory information that could be in that, because the Cellbrite report, it's a physical report, and I know the court is aware of this, and I'm going to need to go through the extraction materials. So I would appreciate if the court could make some type of finding about that in regards to the discovery information, because at this point, it basically boils down to that. Now, we did receive a response. Again, I'm referring to this from Mr. Roloff in regards to the information about the confidential informants. And there were 2 items that were not in the initial disclosure. There was a felony from 2017, and then a couple of pending charges, which I believe one came to fruition yesterday out of, I want to say it's a Sheboygan, Your Honor. And it's actually the same organization, the Straits Area Narcotics Enforcement Unit, prosecuting the confidential informant. So I don't know if we have all the information regarding the confidential informant. So we're asking for full disclosure in regards to the CI. And in addition to that, an opportunity to at least review the data and the actual extraction and not the PDF report, because that would be appropriate. So I mean, I don't like pointing fingers and things, Judge, but some of this stuff doesn't pass the sniff test, so to speak, when we're a month out and there is an email from law enforcement to the chief law enforcement officer regarding, extracting a phone or phones in the present tense. So I would like to, I mean, it would be great if the court would say that this is a violation and that would merit a dismissal. In the event it does not, I really believe it would be appropriate to grant some time so we can review this material with an expert to see what else is on the phone or phones. And also, I believe that there was a phone that was taken from a confidential informant at some point in time that we would also be able to have that extracted. And I also, one more thing, Your Honor, in regards to the discovery and Brady motion, is there were a total of, I believe it was 11 phones that were seized. 2 phones were given back, one to a defendant on another case, which I don't want to use the term co-defendant because they're separate cases, but they're parties that are definitely relevant, and a phone given back to my client, Mr. Hess. We'd like to see the extraction on all of the phones, not just the phones that the police decided that they were going to review and use Cellbrite technology on. So in regards to that motion, Your Honor, again, to wrap up, we're asking for either a dismissal in regards to the timeliness of discovery, because this is, I literally just got this information today. Additional time if the court deems, that there's nothing that merits a dismissal, so we can actually review the extraction, possibly have an expert do it, because that's what will be necessary. And all of the entire information regarding the confidential informant, the main one, who I'm not going to mention the name that's on the record. And that's all I have in regards to those, unless the court has some specific queries for me right now, Your Honor.
Well, I do. First of all, what with regard to the confidential informant, what information are you asking for that hasn't been turned over yet?
I need to know that they have that we've been provided everything. It concerns me that I had to bring this to the prosecutor's attention. I believe that this was a week and a half ago, that there were at least 2 charges that weren't pending. Specifically, I am looking for all the details in regards to the current Sheboygan case, which I haven't checked online, but I believe that came to fruition yesterday, and there was a plea from the confidential informant. So I need all the specifics in regards to that case, anything that was offered, because it appears that this person had gotten a very reasonable plea and had gotten into trouble multiple times since this alleged with the confidential informant that this CI was acting as. So I believe that is the only thing that we're looking for, is that charge. And if there is nothing else that's pending on the CI, who I don't necessarily want to mention that person's name unless the court is querying me or directing me to do that.
Okay, and then with
confidential
regard to
informants are dangerous as it is.
All right, with regard to the cell phones, you said there's 11. Who do those all belong to?
I don't
mean-
want to say anything incorrect. What was explained to me when I reviewed everything with my client is there were 9 or 10 cell phones that would have been seized from a Crystal Emery, who has a case in this circuit that is now in front of Judge Hunter, who we have subpoenaed in this case, Your Honor. But one of the other problems that we have, now I just remembered this, is that individual defendant and witness in this case is pending a competency evaluation, which as far as I'm concerned right now, she hasn't been found incompetent, so she can testify. I don't know if she'll be asserting the 5th, which a lot of the questions that I would be asking this person would be where, etc., location, but nothing that would necessarily be deemed a Fifth Amendment violation or putting herself up in that way. So with all that in mind, Your Honor, there's that issue there, and I don't know if the court finds it necessary to address, but we have there's a pending competency evaluation, which it's my understanding when I spoke with Mr. Garsky, who represents Miss Emery, that he was going to be filing a motion to quash, which I haven't seen yet in regards to the subpoena, which I don't know about the merits of that, and that there is no date for a competency evaluation for Miss Emery. And I believe it will be Miss Emery that had 9 or 10 cell phones that were seized.
All right, and of any cell phones, what reports have you received, Cellbrite reports?
Could the port give me just a moment so I can pull that up on another device, Your Honor?
Sure.
I have from Crystal Emery's phone, I have a total of 4 of them. There'll be 4 from Crystal Emery, and then it would be 1 that would belong to Mr. Hess. So it'd be, I have, this is how it's marked: Emery phone 1, Emery phone 2, Emery phone 3, Emery phone 4, and then we have for Mr. Hess's phone. But those are the reports, not the links or the actual CD or DVD that we'd be able to actually review everything and see if there's anything that's exculpatory that's in there, or
Okay, how long, when did you receive those?
the report, you can't see that.
No, I understand. When did you receive the reports?
About 2 hours ago, Your Honor.
Okay. Thank you. Okay, that's all the questions I have. Mr. Roloff.
Thank you, Your Honor. It's unfortunate when counsel are somewhat disingenuous with the court. There are a number of factors which opposing counsel failed to mention. Specifically, let's start out at the top in regards to his alleged Brady motion. And of course, the court's well aware that Brady are post-trial motions. But setting that aside, as to the information on the confidential informant, this court signed an order in February of 2022, which provided, in response to that order, all of the confidential informant information that was requested. The only information which hadn't been provided was information that, 1, hadn't occurred yet, and 2, were in 2 other counties of which our office had no access to the information. We can't provide, and our appellate courts have found that the prosecutors are not to do defense work as is being requested in this particular case. But since the defense brought it to my office's attention, we went and contacted, I personally contacted those other offices and got all of that supplemental discovery information to the court, some of which was culminated back in June of this year as to one incident, and the other one, I believe, was just resolved in way of a plea. All of that information has been provided to defense counsel. And again, we're talking about, in one case, misdemeanors for which it can't be even used for impeachment purposes. And in the other case, the defense counsel's already been provided that. So to make claims that it wasn't provided is, quite frankly, outright false. As far as claiming that it was not timely provided, well, that is a little bit disingenuous as well, because it hadn't even occurred yet, and it occurred in other counties for which Mr. Jockins could have easily filed a request from those counties. I don't know if he did or he didn't. I didn't ask because it wasn't relevant to our case, but he just automatically expected our office to do that for him. Now, moving on to the Cellbrite information. What defense counsel also failed to mention, as included in the documentation that was provided to him, our office received the Cellbrite report on 12/11/23. That would have been 2 days ago at 11:47 p.m. They received it then, so it was sent out the following morning, so they got it within hours of our office receiving that information. So any claim that we were trying to hide it, again, is at best disingenuous with the court. As to the contents of the Cellbrite report, defense counsel, and I have no idea what type of cases he's handled or where he's gone before courts, but there is no way that he's going to get a link to the Cellbrite agents, the agency that did the Cellbrite report, because giving him access to that link would give him access to proprietary information, which they're just not going to provide. Now, as to the documentation in that report that was provided to him, as this court is also well aware, Cellbrite reports provide all relevant information or information which could lead to relevant information, but they're not going to provide information that has nothing to do with this case. So for defense counsel to argue, well, I need all of this to see if it's going to be somehow exculpatory, I remind the court that mere allegations that granting a request based upon, if the court will remember, the last time we were here back in February of 2022, the allegation that the CI had committed perjury, when in fact that turned out not to be the case. It turned out to be the case that in another state, not Michigan, the CI had been involved in a matter for which, as an accessory after the fact, was charged with effectively a misdemeanor offense for not disclosing to the court at that time that some false information had been placed upon the record. An offense which I'm not even sure would be a crime in the state of Michigan. And that's why that one didn't go anywhere. So we have a circumstance here, Judge, where our office has provided all the discovery information. And by the way, as to the 404B, pursuant to court rule, we don't even have to file that until shortly before trial. But since the court was hearing these matters, the people did the courtesy of providing Mr. Jockins and his client the notice of the 404B information. And since we're dealing with delivery or possession with intent to deliver methamphetamine, the evidence of his multiple prior convictions for running meth labs, delivering methamphetamine, and possessing methamphetamine are clearly relevant and would be admissible under 404B. Thank you, Judge.
All right, thank you, Mr. Jockins.
May I respond very brief, Your Honor? I wasn't sure if the court directed me. I had a difficult time hearing.
Sure, yes, go ahead.
Okay. I appreciate everything that Mr. Rolla has just said. I mean, apparently we have some divergent views, which, I'm not going to, rip on somebody about that, Your Honor. Of great concern, though, is, how old this case is, and we're just getting Cellbrite information today. And Mr. Rolla is correct that he's providing the information that they find is relevant, but that's not what Cellbrite is. So if he doesn't want to give a link, then I believe there'll be appropriate to get me a CD, a DVD, so I can review it with an expert on all of the phones, not just the ones that they felt that they had information on, Your Honor. They seized a lot of phones. One was my client's, and 9 or 10 would have been Miss Emery's. So I am asking for that specific Cellbrite information on a CD, DVD, and that's something that is commonplace in any criminal case because, as the court's aware, there could also be exculpatory information that is on that. And in regards to some of the other information, Judge, there's an ongoing duty of discovery. Court, Your Honor is well aware of 6201, as I believe Mr. Rolla is. If something had just come across me, I'm filing a proof of service and giving whoever that individual is on the other side that information because that's what it says in Michigan Court Rule 6.201. I mean, it's that simple. And to insinuate that I should have to go to a court and find information that's exculpatory. This is a case, I mean, this is the St. area, or excuse me, the Straits Area Narcotics Enforcement Division. Same officers are involved in the case in Sheboygan with this confidential informant as are in this case here. And I have a difficult time not thinking that someone shouldn't have had some sort of knowledge for that in communications like this direct communication email from the detective sergeant from Sane regarding, that, hey, we're still going through this extraction material. We shouldn't have to friggin' dig deep for that. I understand that criminal cases, you get investigators to find these things, but we shouldn't have to get an investigator to find out exculpatory information, Brady information from a county that is related to this with the same drug task force, because that's what it is. It's a drug task force, and trying to put that burden on me. This is a case that I'm not prosecuting, that Mr. Rolla is prosecuting as a chief law enforcement officer of Otsego County. And I understand that he has a job to do, whether I agree with how this is proceeding, that way he's handling it or not. If you're going to go fast and furious and, indicate inculpatory information, etc., then it needs to be fair. And what would be fair is if we're granted a modest adjournment and we're able to get the actual extraction disc, which it doesn't have to be a link, but it's been a link many times before. So I can review it with an expert and see what's in there. Because right now, a lot of the things that have been provided are either incomplete, suspect, or as Mr. Roll had indicated, he made a determination of what he thought that was relevant. And we're asking for everything in there, at least an opportunity to review that, Your Honor. And I'm not trying to back up the court's docket. There's a serious case with there's not even, this isn't even a straddle cell situation, Judge. So I'm either asking for a dismissal in regards to that pertaining to the Cellbrite cell phone extraction, because this is late in the game. And you heard Mr. Rolla, he had just gotten it on I think it was the 11th. And I had just gotten the PDF reports, not the actual extraction disc or link. So those are the things that I'm asking for in regards to that motion, Your Honor.
Judge.
Okay, and then Mr. Jackins, 1 second, Mr. Roll, and then I'll give you an opportunity. Mr. Jackins, there's a bunch of other categories of information that you requested in your motion that you haven't addressed today. So I don't know if you want to address any of those other things.
If the court would give me just a second.
There's 6 different categories of information that you requested.
That came out, my apologies, Your Honor. Okay. And I'll say we have the I would like the protocol and procedure that they have from the Straits Area Narcotics units. Any sort of handbooks that they have, and that would be in subsection A and B. I need the names of all the witnesses. I have what was on the actual information, but there isn't a witness list that's been provided. And any sort of credentials, especially if there's going to be an officer that is going to be testifying in regards to cell phone extraction, Your Honor. And I believe that would be Sergeant Lacoste at this point. And I believe that a CV would probably resolve that. And then the most important thing that I had found in this is in sub paragraph D, which would be any and all data from any cell phone that was seized. Cellbrite data dump of any text or other messages evidencing that certain alleged transactions at issue occurred and at certain times, which these are things that Mr. Rolla had just addressed a couple minutes ago. Let's see, and then the names of anybody pertaining to the alleged drugs at issue, which I think that we have those people. I believe that there's 2 confidential informants that were named. And why one of the reasons why I'm digressing here real quick, Judge, is why we need to go through that is it appears that in the discovery, we have text messages that were like thrown in there from another case. And I went over this with my client, investigator went in it, and it's not really making any sense. So that's the other reason why that's critical. And that's essentially all that I'm asking for, Judge. I think that a CV would take care of a lot of that. A witness list would take care of it. And the biggest concern is in regards to the Cellbrite, the cell data dump, and the actual raw data. So that can be reviewed, and we can review everything that's in there, regardless of what the prosecutor's office finds relevant, Your Honor.
Thank you, Mr. Rolla.
Yes, Judge. Again, twice, defense counsel's again falsely stated things for the record. It's not that the prosecutor's office found it relevant, sir. And I apologize, Judge, court. It's that the person who did the analysis at the CCU found relevant. As this court's well aware, they reviewed tons of data. And if there's data in there that deals with things that have nothing to do with this case, they're not going to include it in the Cellbrite report. I don't make the decision as to what's relevant or not relevant, as has been 3 times now alleged on this record by defense counsel. The CCU does that, as the court's well aware, because we've had many cases with Cellbrite information before. Additionally, this claim that defense counsel wants a disk and all they got was a PDF of information. All that's going to be on the disk, Your Honor, is a disk that contains the PDF files. It doesn't change anything. It's still a PDF file. That's the way the data is stored. Defense counsel may not like that, but there's a lot of things I wish were different, but the reality is it's still a PDF form. As far as the CV, by the way, that's not coming from the Detective Lacrosse. That's coming from the person who did the Cellbrite data dump. And I'll have to check, but I believe that's a Sergeant McMillan. As to the list of the witnesses, no, the people haven't filed a list of witnesses yet, because pursuant to the court's policies, those are to be filed 14 days prior to trial. And as defense counsel has said several times, we're a month out. That's more than 14 days. I've been involved down in the Supreme Court, as the court's well aware, last Wednesday. And I had another matter that took me downstate yesterday. We will be providing a witness list, but of course, depending on how this court was ruling would be depending on who is going to be called for trial. So at best, again, that request is premature. Thank you, Judge.
All right, Mr. Jackins, anything further that you wanted to say on the discovery issue? Sorry, you're muted, Mr. Jackins.
My apologies, I was on mute. Just the opportunity to get the actual extraction material, Judge. I've gotten those multiple times. I've gotten them multiple different ways. I'm doing my best to be polite. I don't know why someone would not, allow an opportunity to review that, because at the end of the day, that could also lead to a plea in this matter. The PDF is not the data dump. That's the report. I'm entitled to go through that. There's things that could be in there that are exculpatory. I don't know what they are. And right now I'm guessing, and there's a total of, I believe, 5 phones, 4 from Miss Emery right now, that there is a Sellbright report, 1 from Mr. Hess, and then there's another 4 or 5 phones that were Miss Emery's that we've just gotten radio silence on. So that's what I'm asking, Your Honor. And then I would like some time to speak with an expert to see what we need to do to, defend that aspect of the case, or to determine if there's another motion or so that I might need to file regarding that, Your Honor.
All right, thank you. Okay, I've had a chance to hear the arguments of counsel here on the record today with regard to these discovery issues. And first of all, I mean, there's been plenty of delays in this case. Certainly some of them have been attributable to Mr. Hess. He switched counsel during the pendency of this case. We had counsel file a motion for a competency exam. And, Mr. Jockin's firm has been on this case since last February, and certainly some of these discovery issues could have been addressed well before now. I am surprised that we haven't had the cell phone extraction take place prior to now. But certainly, everybody's known that those cell phones were seized, and so again, I think these motions could have been brought at an earlier time than now, even if the report was just generated recently. So yeah, this case is certainly overdue. It's been delayed, but I don't think that the delay is all on one side or the other. I think there's been delays caused by both sides in this case. So I don't find the delay in and of itself on the part of either side to be a basis for any kind of dismissal, certainly not a dismissal, and perhaps not even an adjournment of the current trial dates. With regard to discovery, the court rules cover discovery and each party's right to discovery in a criminal case, and both sides are aware of that. Both sides have accurately cited the court rules and authority, which entitles each side to discovery. The prosecutor is certainly required to turn over relevant information to the case. However, the prosecutor is not required to develop evidence or develop information. The prosecutor is required to turn over information that they have that's helpful or favorable to the defense, and that's material to the case. So prosecutor's office isn't required to turn over information that it hasn't developed. And I think some of this falls into that category. And they're not required to go out and look for information or help the defendant find information or develop information. They're only required to disclose and turn over information and evidence that they have. So using all of that as a backdrop here, and certainly the information has to be relevant and not privileged. Looking at the requests by the defendant, paragraph A and B, which deals with procedures, handbooks, manuals, so forth. There hasn't been any citation of any authority as to why those would be discoverable in this case. So the court finds that the defendant isn't entitled to an order compelling disclosure of the information contained within A and B of the motion. With regard to any witnesses, the court is simply I don't think the defendant is entitled to anything more, or the prosecution for that matter, more than what the court rules and the pretrial order of the court require in terms of disclosure of witnesses. So the court's, I don't think an order compelling anything here is necessary. I think both sides are required, again, under the court rule and the pretrial order of the court, to disclose the names of any witnesses and the substance of their testimony and so forth that's laid out in the court rules. And I don't find that there's been failure of either side to do that as of this point in the case. And I don't think the defendant's entitled to anything more, and neither is the prosecution for that matter, than in terms of information, credentials, and so forth, than what's required under the law. And so the court isn't going to order the disclosure of any information beyond what's in the plain language of court rules. With regard to the cell phone data or the raw data, I appreciate counsel's representations that they frequently get this information. I don't know what those cases where defense counsel's gotten that information in the past, how relevant the raw data actually was in those cases versus this case. But the defense did not cite any case law indicating that under the circumstances here that it would be entitled to all of that raw data on the 5 phones that it looks like there were cell-bright analysis done. And the fact that it might contain some kind of information, I don't think requires the prosecutor to, again, develop all of that, compile that, and then give all that raw data to the defense. So as to the phones that have been analyzed, the court doesn't find that there's been any showing legally or factually that the defense is entitled to all of that raw data. As to any other phones that might exist that haven't been tested, I don't think the defense has provided any authority for the court ordering the prosecution to go through that, produce reports, and provide those reports to the defense. Again, the prosecution is not required to develop information, do discovery for the defense, and find out what's on those phones and then turn it over to the defense. And there's no showing that any of those other phones would even have anything relevant or material to this case just because they belong to a person connected with the case. Is far from showing that they contain any information that would give any kind of indication that they are relevant or have material information that relate to this case. So for those reasons, the court is going to deny the defense motion for discovery based on the reasons the court stated for the record. Moving on, Mr. Jockins, to your Frank's motion. So there are a couple of components to that, as I can tell. First of all, you're challenging the warrant itself based on the credibility of the information. Your arguments are that the confidential informants weren't credible and they didn't, or that the information that they gave to support the warrant wasn't reliable. And to me, that's a separate issue than whether or not you're entitled to a Frank's hearing on the basis that the affiant gave a statement that was knowingly or intentionally false or with reckless disregard for the truth. So to me, those are two separate issues. And then with regard to the Frank's thing, I mean, based on my research, the defense has to make some kind of showing that the statement was false before the court would order an evidentiary hearing. Can you address those issues for me?
Judge, in regards to the Frank's matter, it's like a Walker hearing. I mean, we should be entitled to that, and to be able to get testimony from the officer. In regards to the credibility of the witnesses, there's 2 witnesses in this case. One that I'm really referring to, in the confidential informant, that definitely has some veracity and mendacity issues, and that has been continuously shown a criminal pattern. And it would be appropriate to inquire to that police officer or officers as to what they did in the background to get that. I don't have anything that's specifically materially false, and the material false allegation isn't necessarily something that would generate a Frank's hearing. And as the court is well aware that even after a Frank's hearing, the court could find something that was improper happen. I've had this happen before, but apply the good faith exception that in this circumstance, which I don't know if the court would view it that way.
So
that's where I'm at in regards to the Frank's matter. And I do have one question from the court. Sorry to get out of order, Judge. I'm hoping the court will at least allow us to review the cell phone raw data, because I have never had a situation where I've never been able to get a disk or an actual link, because that's stuff that you don't want to see. And I will share something with you, Judge, since you brought something up, if that's okay. Yes, I have had cases with cell phone raw data extraction. And as a matter of fact, on one of them, interesting stuff that I found on a drug case, a conspiracy case, as a matter of fact. Of course, I get the PDF, which has everything in there for the actual text messages, things of that nature between whoever the parties would be. But what they don't show is stuff that's deleted. They won't show, something that someone posts on there like, nobody should trust me because I'm always plotting and planning. Or, something to the degree of, well, I don't regret doing things, like this. This is how my life has been. And of course, we're not going to get that from a prosecutor on any case. That's why, we get the raw data that's from the cell phone extraction. Because yes, they're giving what's relevant. But at the end of the day, this is essentially Brady material. There could be exculpatory information that's on there. And the police and the prosecutor don't necessarily comb through the Cellbrite cell phone to say, okay, here's exculpatory information.
Your Honor, may I respond?
So that's the issue on that. In regards to the Franks, asking for a hearing regarding that and what the people and actually what the officer in the situation relied on, and for the affidavit for search warrant to actually get the search warrant.
Okay, so again, with regard to the raw data and the Cellbrite report, I appreciate your statements, but I don't go on anecdotal statements of counsel in determining whether they have a legal right to something. You need to cite cases. You need to provide me with some authority that says that under these circumstances, you're entitled to all of the raw data. I mean, there could be exculpatory information anywhere in the world with regard to this case on, intersection cameras. I mean, there could be information anywhere in the world relating to, or that might potentially have exculpatory information, but you wouldn't be entitled for the court to order, the prosecutor to obtain from the city of Gaylord all the traffic light camera information on the date here. Under these circumstances, maybe you would, but you'd have to provide some kind of authority to the court showing that it's relevant and it's material. And just telling me that other courts have given you that in other cases, and maybe they did, but maybe there was a reason for that. And maybe the facts of those particular cases or what was on that data justified the courts in those cases having that raw data disclosed, but you haven't provided that to me here other than just saying you want to go through it. And in my view, that's not enough for the court to compel the prosecutor to turn over the raw data underlying the report. And it's certainly not a reason why the court's going to delay the trial in this case. So that's really all I have to say on that subject. The motion's denied, and I guess to the extent that you want to appeal that, that's an appealable issue. As it relates to the Franks issue, I'm looking at your brief, and what you cited under the Franks decision says, where the defendant makes a substantial preliminary showing that a false statement knowingly or intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit, and if the allegedly false statement is necessary to a finding of probable cause, then the Fourth Amendment requires that a hearing be held. So I'm trying to understand where you're saying that you're entitled to an evidentiary hearing right off the bat, because the portion that you cited in your brief seems to me to require some kind of preliminary showing by the defense. And correct me if I'm wrong about that.
I have nothing further than what was offered
Okay.
in the brief and from what I had just said, Your Honor, in regards to the Franks issue.
Judge, as to the Franks issue, if I may.
Yes, go ahead, Mr. Rowland.
Thank you, Your Honor. The basis for the search warrant, as the court saw in the affidavit, is 3 observed hand-to-hand buys. And then the person doing the hand-to-hand buys being trailed back to a hotel room, which was registered in this defendant's name. That was the basis for the search warrant. It's not based upon speculation by any officers. And again, on this record, defense counsel admitted he's not aware of any false statements in there. So there is absolutely no showing for an evidentiary hearing. Actually, all the evidence is to the contrary. Thank you, Judge.
All right, thank you. So looking at the issue, and I do think that defense did properly cite the law that applies in this case. First of all, with regard to the basis for the search warrant itself, the search warrant has to include affirmative allegations from which the magistrate could conclude that the person either has personal knowledge of the information, and if it's an unnamed person, that there's some indicia that that is a credible individual or that the information is reliable. In this case, the defense's motion argues that, well, it indicates, and they're correct, that we do not have identification of the individuals. They're confidential informants identified only by number. The defense argues that there's no corroborating information for evidence for the information that's given, a lack of specificity or particularity, and there's no information that would indicate that the informants are reliable, and therefore that second prong of the requirement isn't met. I did review the search warrant and the affidavit supporting it in this case, and the court finds that the affiant did give very specific information, and the court points specifically to paragraphs I through M of the affidavit, as well as Q through S. And based on the information in there, the court finds that those are specific and particular facts, and it's not merely boilerplate language. There is specific facts that are particular to this case in there that the affiant sets forth, which in my view would meet the minimum standards for a magistrate to find that there was adequate reliability of the information contained within the warrant. As it relates to the Franks hearing, again, I've already indicated what I consider to be the controlling portion of the Franks holding in this case. And the court finds that the defense has not made that preliminary showing. They have relied on really just conclusory statements that they believe that the affiant relied on false information or gave false information as part of the affidavit without any kind of, certainly not a substantial preliminary showing that the affiant did that. So for those reasons, the court finds that that motion should be denied as well. So Mr. Rollo, the court will ask that the people prepare an order that reflects the ruling of the court today as to the motions and submit that under the 7-day rule. The court is going to deny any request to adjourn trial and will proceed with the trial dates as currently scheduled in January. That's all I have for the record today, and all parties are free to disconnect at this time.
Judge, one issue as a procedural matter, if I may, housekeeping.
Yes.
For the 18th now no longer going to be taking place? Because there was a date originally scheduled by the court. I know we did a stipulation in order to move things to the 13th. I just want to make sure that that final status conference for the 18th is not going to be held. Otherwise, I'll be there for the court.
Honestly, I did not look at the docket for the 18th, so I don't know. If it's on, we'll have the hearing. If it's not on the docket, we won't.
Very good. Thank you, Judge. I didn't want to miss it if I was supposed to be there. That's all.
Your Honor.
Yes.
If I may interject, not to interrupt Mr. Rolla or the court, but the stipulated order moved the review hearing status conference to today as well.
Correct. That's
so I don't know if we need to, if the court wanted to specifically address anything in that. I don't, know what the protocol and procedure is, and I just want to make sure everything was followed.
Sure. I think what I'll do is set this for a final status conference in January prior to the trial dates. I think given the rulings today and the uncertainty regarding the motions leading up to today, that both sides may want to have a chance to digest the rulings today, and then we'll have a final status conference prior to the trial date.
Thank you, Judge.
The court will send out notice of
Thank
the
you.
date and time of that. And Mr. Jockins, if you want to appear by Zoom for that as well, I don't have any objection to that. Just let my office know ahead of time.
Thank you, Your Honor. It's much appreciated.
Okay. All right. Thank you. That's